The Superior Court of California, County of Los Angeles, would like to welcome you to the Probate Conservatorship Orientation for Non-Professional Conservators. This is an overview of probate conservatorships. In this program, we will provide you with some general information about probate conservatorships and discuss the conservatorship of the person. Much of the material presented in this orientation is covered in the Handbook for Conservators. This handbook is available at no cost at www.courts.ca.gov/documents/handbook.pdf or for purchase at the probate filing desk as a hard copy. We will not be providing any legal advice. If you need legal advice, you can contact the Los Angeles County Bar Association for a referral to an attorney. You may also qualify for free legal assistance through a local legal aid agency. California law considers anyone who is age 18 years old and above to be an adult. With adulthood comes the right to independently manage personal affairs and finances. The law presumes that adults have the independence, maturity, intellect, and capacity to make life choices and to tend to personal daily living activities. Adults have basic civil and legal rights under the law to make their own decision, such as deciding where to live, who to marry, whether to seek medical treatment, how to manage their finances, or what tasks need to be done for self-care and maximum independence. But what if an adult is disabled in some way, and this interferes with their inability to manage personal and financial affairs? What if the disability makes them vulnerable to physical abuse or being financially taken advantage of by others? If an adult lacks the mental function to understand the results of their actions, or lacks the ability to make informed decisions on their own due to an injury, developmental disability, dementia, or other mental or physical condition, our society recognizes they may need extra help. Our laws provide a way to have someone else step in to help that person in a legal proceeding called a conservatorship. In California, a conservatorship is a court case where a judge appoints a responsible person or organization to care for another adult who is unable to manage on their own and needs help with their personal and/or financial affairs. The person or organization appointed to care for the adult is called a conservator. The person who needs assistance is called a conservatee. The goal of a conservatorship is to act in the best interest of the conservatee, providing help where needed, while at the same time making every effort to assure that the conservatee lives as independently as possible. Alternatives to conservatorships. A conservatorship may not be the best option in every situation. There might be other ways to accomplish the same thing. A conservatorship involves limiting some of the civil and legal rights of a disabled adult by court order, a rather severe act that limits a person's right to independence and the ability to make their own decisions. Alternatives to a conservatorship should be explored first. Whether any alternative is an appropriate option will depend on the capacity of the disabled person to understand its purpose and the consequences of choosing such an alternative. If a disabled person has the capacity to understand they need help in certain areas and are of sound mind to voluntarily give someone the authority to act on their behalf, a conservatorship may not be necessary. So before moving forward with a conservatorship appointment, the court will want to know if it is possible to help the person through any of the following ways. Formal or informal help. If the disabled person understands they need help and can voluntarily accept formal or informal help from someone or other support services in the community, a conservatorship may not be necessary. The disabled person can seek assistance through their circle of family members, friends, fiduciaries, or other trusted individuals to make personal, financial, or legal decisions. A fiduciary is a paid professional who takes care of money or other assets for another person. Power of attorney. A power of attorney is a legal document that allows a person of sound mind to appoint any trusted individual to act on their behalf in legal matters in the event they cannot handle those matters themselves. The person who creates the power of attorney is called the principal, and the trusted person who is appointed to act on their behalf is called the agent. A general power of attorney gives broad powers to a person or organization to act on behalf of someone. This might include decisions related to medical treatment or legal matters related to financial and business activities. A special power of attorney allows a person to specify what powers an agent can exercise. It is often used when someone cannot manage their affairs due to their commitments or health reasons. For example, someone might use a special power of attorney to give a trusted individual authority to sell property, manage real estate, collect debts, or handle business transactions. Another special power of attorney may give a person's spouse specific authority to make medical decisions on their behalf. In the event a person becomes mentally incompetent due to illness or accident, a general or special power of attorney can have special provisions which will keep the document in effect. This is called a durable power of attorney. A durable power of attorney can be used to prepare for the possibility of becoming mentally incompetent due to illness or injury, and will specify that the power will not become effective until a doctor certifies the person is mentally incompetent. A power of attorney will not remain active once the person creating it passes away. Usually, a last will or trust or other estate planning document, if in place, will take effect upon the person's death. Advanced Healthcare Directive. A durable power of attorney for healthcare, sometimes called an Advanced Healthcare Directive, allows an adult with capacity to name an agent to make healthcare decisions, including accepting or refusing treatment. The provisions can give the agent authority to make end-of-life decisions according to the principal's wishes, name a conservator in the event one can become necessary, give the agent access to medical records, and carry out any specific burial arrangements. This directive can take effect immediately or when the person creating the directive loses capacity. It requires 2 witnesses or a notary and can be revoked as long as the principal has capacity. Trusts. A trust is another way to manage property or other assets for the benefit of someone without the need for a conservatorship. A trust is a legal plan which provides that certain funds and assets be placed under control of another person or organization called a trustee for the benefit of another person called a trust beneficiary. The person or entity who creates the trust is called a settlor. The person appointed to manage and carry out the terms of the trust according to state law is called a trustor. Sometimes the same person can be the settlor and serve as the trustee. There are different kinds of trusts, but a common type to become familiar with in regard to disabled individuals is called a special needs trust. This type of trust allows a person to benefit from assets held in a trust without losing government benefits of Supplemental Security Income, SSI, and Medi-Cal. The funds in such a trust are intended to supplement any government benefits received rather than replace them. In a special needs trust, the beneficiary does not have control over the trust money and cannot decide how the funds are used. Rather, the trust funds must be distributed to a third party to pay for goods and services for the beneficiary. The funds cannot be distributed directly to the beneficiary. Instead, the trustee will use the funds to pay for things such as medical expenses, not covered by insurance, personal care attendants, transportation, rehabilitation, special dietary needs, recreation, computers or electronic equipment, furniture, trips and vacations, and entertainment of the beneficiary. The creation of a special needs trust can require initial legal fees for its creation and ongoing accounting fees and legal fees for continued management. Many people may not have enough money to create and support a special needs trust on an individual basis. In such a situation, a pooled trust might be a better option. In a pooled trust, several families with more limited resources jointly collect funds for investment purposes in a trust that is managed by a nonprofit association. The nonprofit association acts as the trustee for all the beneficiaries and manages the funds in a way so that any government benefits will not be lost for any individual of the pooled trust. Joint accounts. Another alternative to a conservatorship is to set up a joint or custodial account with a bank. These accounts allow two or more individuals to withdraw or deposit funds in the account to use for the disabled individual's personal expenses. Setting up a joint account with a spouse or domestic partner can allow one spouse or partner to manage financial transactions of community property on behalf of the disabled spouse or partner. The couple can use a durable power of attorney for finances to authorize management of the disabled spouse or partner's separate property. Blocked accounts. If the disabled individual is to receive money from a judgment or settlement of a court case, sometimes a blocked account will be established. These blocked accounts are overseen by the court, and funds can only be withdrawn by filing a request to the court. Education authorizations. The California Education Code, beginning with Section 5600, describes how a disabled adult can receive help in making educational decisions. Educational institutions have consent forms which allow an adult with an intellectual or developmental disability to authorize another person to make education decisions for them. The consent forms may also allow for the release of the records to a designated agent. Medical authorizations. If a situation arises where a person lacks capacity to make a healthcare decision concerning a specified treatment for an existing or continuing condition, it is possible under the California Probate Code, Section 3201, to petition the court for authorization to make that specific healthcare decision for the incapacitated person. Representative payee. If a disabled person receives government benefits such as Supplemental Security Income, SSI, Social Security Disability Income, SSDI, and needs help with handling these benefits, an alternative to a conservatorship is to be appointed as the representative payee. While the benefits belong to the disabled person and the check will be payable to them, the representative payee's name will also appear on the check. This allows the representative payee to receive, deposit, and spend the government benefits on behalf of the disabled person. The payee must spend the benefits appropriately for the disabled person's needs, properly account for the money spent, and make regular reports to the Social Security Administration of any changes in the life or living situation of the disabled person. Authorized representative. A disabled individual may appoint a representative to help them with the management of Medi-Cal and in-home supportive services benefits. This authorization can include having another person assist them at public benefit appeals and state administrative hearings. Deciding what help is needed. If none of these alternatives are possible or appropriate, then a conservatorship may be the best option to assist someone who is incapacitated. Before filing for a conservatorship, it is important to first consider the disabled person's needs. Is there a need to help with daily living activities and physical care, such as personal care, health care, meals, clothing, shelter? Is there a need to help with the management of money, finances, and property? What the disabled person needs will determine what type of conservatorship for which to petition. There are two categories of conservatorship which describe the areas of help needed in a conservatee's life: conservatorship of the person or conservatorship of the estate. A person who is appointed to be the conservator of the person has the duty to help the conservatee with life activities related to physical needs. A person who is appointed to be the conservator of the state has the duty to help the conservatee with matters related to money, property, or finances. A person can petition to be appointed as the conservator of the person, conservator of the state, or conservator of the person and estate. Conservator of the person. Before the court can appoint a conservator of the person, it will be necessary to gather information about the specific physical needs of the proposed conservatee. The court will consider facts about these needs from the person who requests to be appointed as the conservator, any family members involved in the conservatee's life, and the proposed conservatee. The court will consider reports from the disabled person's medical doctor, their attorney, the probate investigator, and in the case of a developmentally disabled individual, a regional center. Once it is clear what help the conservatee needs, the court will decide what duties to assign the appointed conservator. Some examples of the duties that might be assigned to a conservator of the person include the following: to provide for the care and protection of the conservatee, to decide where the conservatee will live, to seek permission from the court to move the conservatee out of state, to provide for the health care, meals, clothing, and personal care of the conservatee, to provide for the housekeeping, transportation, and recreation of the conservatee, to make informed decisions about medical care and consent to appropriate medical treatment. In the case of dementia, to place the conservatee in a secure facility and authorize the use of medication to treat the dementia, to notify the court of any change of residence, and to report to the court of the status of the conservatee. Conservator of the estate. If a proposed conservatee needs help managing money or property, or may be vulnerable to financial abuse due to a disability, the court will use the same resources to gather information about the proposed conservatee's abilities to handle finances before appointing a conservator of the estate. A conservator of the estate's role is to manage the conservatee's income responsibly and to protect the conservatee's assets. This might involve the duty to locate and take control of all assets, prepare a budget, collect income, pay bills and taxes on time, invest wisely, and ensure the conservatee receives all the income and benefits to which they are entitled. The court will monitor how the conservator of the estate is handling the conservatee's finances by periodically reviewing an inventory and appraisal. An inventory and appraisal is a list of the assets and the value of those assets the conservatee owns. It is the responsibility of the conservator of the estate to submit an inventory and appraisal to the court within 90 days after the appointment. Note that if the assets in the estate are worth $15,000 or more, they may require the conservator of the estate to post a bond. If a conservatee needs help with both physical needs and finances, it is possible to seek the appointment of conservator of the person and the estate. The petition should include information about the conservatee's incapacity and details why it is necessary to manage these areas of the conservatee's life. Deciding what type of conservatorship is appropriate. General conservatorships and limited conservatorships. There are two types of conservatorships: general conservatorships and limited conservatorships. The conservatee's diagnosis and the timing of when the disability began in the conservatee's life will determine which type is appropriate. General conservatorships. A general conservatorship is appropriate for any disabled adult who becomes incapacitated by an injury, disorder, condition, or disease. The conservatee was not born with a disability, but now needs a higher level of care and assistance in managing personal and financial affairs. This type of conservatorship is appropriate for an elderly person who may need help due to difficulties associated with advancing age, such as dementia or other related health issues. However, a general conservatorship can be appropriate for any adult who experiences some event or the onset of a condition that interferes with their ability to independently handle personal daily living activities or manage financial matters. The court will consider what is in the best interest of the conservatee and, with that in mind, grant the general conservator specific powers and duties to meet the conservatee's needs. The goal is always to ensure the conservatee receives appropriate care and protection while at the same time allowing them to live in the least restrictive environment with maximum independence. Limited conservatorships. A limited conservatorship is appropriate for adults with a developmental disability. Examples of a developmental disability include the diagnosis of autism, intellectual disability, Down syndrome, or cerebral palsy. These individuals have a severe or chronic disability due to a mental or physical impairment that began before reaching the age of 18 and is expected to last indefinitely. Because their growth and development may have been delayed or impaired, developmentally disabled adults may need special assistance in certain life activities, and a limited conservatorship is designed to provide help in those activities while encouraging further development where possible. The focus is to help the limited conservatee develop maximum independence in the least restrictive environment. In a limited conservatorship of the person, there are 7 powers or duties that can be assigned to the conservator. The court may grant some or all of these powers and duties to the conservator, taking into consideration the specific needs of the proposed limited conservatee and their cognitive abilities to act independently in certain life activities. These powers include the following: to decide where the conservatee will live, to have access to confidential records such as mail, medical records, test results, or other writings, to control the conservatee's right to enter into contracts, to give or withhold consent to marriage or a domestic partnership, to give or withhold consent to medical treatment, to control the conservatee's sexual or social contacts, and to make decisions concerning the conservatee's education. In a limited conservatorship of the estate, a limited conservator will have the authority specified by the court concerning the management of the conservatee's monies, finances, or property. It is important to note that anyone seeking the appointment of a limited conservatorship for someone who is a resident of Los Angeles County must provide the court with a report from a regional center. Regional centers are nonprofit corporations that have a contract with the California Department of Developmental Services to serve those with developmental disabilities throughout the county, regardless of age or degree of disability. They provide numerous services that include the following: diagnoses, evaluations and treatment, physical or occupational therapy, job training and education, counseling and protective services, referral and information resources, advocacy, and respite care. In most cases, the court will want to consider a report from a regional center that addresses the proposed conservatee's needs, abilities, and background before appointing a limited conservatorship. Ending a conservatorship. A probate conservatorship, whether a general conservatorship or limited conservatorship, will last indefinitely. The appointment is expected to continue as long as the conservatee needs help due to the disability or incapacity. However, there are some instances where conservatorship can end. A conservatorship may end when the conservatee dies. It also may end if the court decides a conservatorship is no longer needed because some change has occurred which allows the conservatee to manage their personal or financial affairs independently. For example, the conservatee is no longer incapacitated and can now handle personal affairs, or in the case of a conservatorship of the estate, the assets have been exhausted and there is nothing left to manage. If the court determines the conservator is not properly performing the duties assigned, the conservator may be removed and a new conservator will be appointed. A new conservator might also be appointed if the original conservator dies or resigns. The probate code is particularly specific when defining when a limited conservatorship ends. Under the probate code, a limited conservatorship will continue until one of the following occurs: the limited conservator dies, the limited conservatee dies, a general conservator is appointed, or the judge ends the limited conservatorship. When a petition for conservatorship is filed, a probate investigator is assigned to provide the court with a report and recommendations in advance of the initial hearing. Probate investigators are employees of the court. They are experienced human services professionals with bachelor's or advanced degrees. They have experience in working with vulnerable populations such as frail, elderly, or persons with developmental disabilities and their families. They have the authority to examine the proposed conservatee's medical records and conduct interviews relevant to assessing the petition or review of the conservatorship. The probate investigator may conduct field visits, visiting proposed conservatees and conservatees in their homes or facilities. The probate investigator will carry a court picture identification card. Probate investigations in the field by law may be announced or unannounced. A copy of the probate investigations report is released to the petitioner, the proposed conservatee, their attorneys, the conservatee's spouse or registered domestic partner, relatives within the first degree named in the petition for appointment, and any other person the court orders. The court may order that certain persons not receive a copy of the report if it feels the delivery will harm the conservatee. The investigator will interview the proposed conservatee privately to inform them of the petition for conservatorship and what it means. The probate investigator will determine if the proposed conservatee agrees or objects to the petition for conservatorship, and if they agree or object to the appointment of the proposed conservator. The investigator will also ask the proposed conservatee if they would like to be present at the hearing and speak to an attorney. The probate investigator will ask the proposed conservatee if they wish to participate in the voting process should the conservatorship be granted. The probate investigator will also interview the proposed conservator, the proposed conservatee's spouse, if applicable, and first-degree relatives. Friends, neighbors, and other relatives may be interviewed as well. The probate investigator will assess the proposed conservatee's living situation, care, and inquire about their finances, diagnoses, and medical care. After the petition has been granted, the probate investigator will visit the proposed conservatee yearly or biannually to review the conservatorship or to investigate a complaint. The probate investigator will ask the conservatee if they wish to make any changes to the conservatorship and assess whether the conservator is serving the conservatee's best interests. The fees for the initial probate investigation are included in the fees paid at the filing of the petition unless a fee waiver has been granted. Charges are assessed for the probate investigator's yearly or biannual review of conservatorships after the initial appointment.